You mean I have to identify all of the family members of the person that died? Hi, I'm Darren Findling of the Probate Pro, and the question that gets asked all the time is, how do I deal with a family member who hasn't spoken to us in many years? They've been excommunicated, estranged, they're gone, they're out of the picture. Why am I required to list that family member on the probate documents before we file with the probate court? Well, the answer is pretty straightforward. There are people that are specifically entitled to notice of the proceedings in probate when you are opening an estate. So, for example, in a context in which somebody dies and there is a spouse and children, the spouse and children are all entitled to notice. Even if there's a will, even if there's a will that excludes some of the family members, all of them are entitled to notice, and all of them must be listed on the original application or petition for probate with the testimony to identify heirs, specifically identifying their names and, when the filing occurs, their address. So one of the problems that arises is with an estranged family member is remembering their whereabouts. You may not know where they are. You may not have spoken to them in many, many years. It is a requirement to give notice pursuant to the court rule and statute for all of the people that are entitled to notice under the filings of a petition or application for probate. So you have to find those addresses, or you have to do your due diligence to locate their whereabouts. If you can't, if somebody has been missing so long that you can't, there is a process that allows publication to occur. Remember, you're signing the petition and application and testimony under the penalties of perjury. You are required to fully disclose all of the names of the people that are required. You can't just skip over them because they no longer are participating in typical family functions. One of the responses I get when I ask, how many children did the decedent have in their lifetime? People will often say, well, there were 3. But we haven't spoken to Johnny in 20 years, so we don't need to include them. And that's just simply not the way the statutes work. Notice is required to all of the interested parties as set forth by statute and court rule. And you have to do so on the testimony and related probate documents. If you've got questions about probate, if you've got questions about the family tree, reach out to us at theprobatepro.com or visit us at 833-PROBATE.